Magna Carta from Wikipedia. English Charter of Freedoms, 1215. This article is about the English Charter of 1215. For other uses, see Magna Carta. Disambiguation. I don't know what that means actually. Magna Carta Libertatum, medieval Latin for Great Charter for freedoms, commonly called Magna Carta, also Magna Carta. Magna Carta, the Great Charter. Great Charter is a royal charter of rights agreed to by King John of England and Runnymede near Windsor on the 15th July. On 15 June 1215, first drafted by Archbishop of Cambridge Stephen Lawton to make peace between the unpopular king and the group of rebel barons. It promised a protection for church rights, protection for the barons from illegal imprisonment, access to swift justice, and limitations on feudal payments to the crown, to be implemented through a council of 25 barons. Neither side stood behind their commitments, and the charter was annulled by Pope Innocent III, leading to the First Barons' War. After John's death, the regency government of his young son Henry III reissued the document in 1216, shaped some its more radical content in an unsuccessful bid to build political support for their cause. At the end of the war in 1217, it formed part of the peace treaty agreed at Lambeth, where the document acquired the name Magna Carta to distinguish it from the smaller Charter for the Forest, which was issued at the same time. Short of funds, Henry issued the charter again in 1225 in exchange for a grant for new taxes. His son Edward I repeated the exercise in 1297, this time confirming it as a part of England's statute law. The charter became part of English political life and was typically renewed by each monarch in turn. Although as time went by and the fledgling Parliament in England passed new laws, it lost some of its practical significance. At the end of the 16th century, there was an upsurge in interest in Magna Carta. Lawyers and historians at the time believed, and there was an ancient English constitution going back to the days of the Anglo-Saxons that protect individual English freedoms. They argued that it's a normal image of 1066 and overthrown this right, that the Magna Carta had been a popular attempt to restore them, making the Charter an essential foundation for the contemporary powers of Parliament and legal principles such as habeas corpus. All of this historical account was badly flawed. Jurists such as Sir Edward Coke used Magna Carta extensively in the early 17th century, arguing against the divine right of kings propounded by the Stuart monarchs. Both James I and his son Charles I attempted to suppress the discussion of Magna Carta until the issue was curtailed by the English Civil War of the 1640s and the execution of Charles. The political myth of Magna Carta and its protection of Asian personal liberties persisted after the Glorious Revolution of 1688 until well into the 19th century. It influenced the early American colonies in the 13 colonies and the formation of the United States Constitution, which became the supreme law of the land in the new Republic of the United States. Research by Victorian historians show that the original 1215 Charter had concerns medieval relations between the monarch and the barons rather than the rights of ordinary people. But the Charter remained a powerful, iconic document even after almost all of the content were repealed from the statute books in the 19th and 20th century. Magna Carta still forms an important symbol of liberty today, often cited by politicians and campaigners It is held in great respect by the British and American legal communities. Lord Denning described it as the great constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot. In the 21st century, four exemplifications of the original 1215 Charter remain in existence: two at the British Library, one at Lincoln Castle, and one at Salisbury Cathedral. There are also a handful of the subsequent charters in public and private ownership, including copies of the 1297 Charter in both the United States and Australia. The original charter was written on parchment sheets using quill pens in heavily abbreviated medieval Latin, which was the convention for legal documents at that time. Each was sealed with a royal great seal made of beeswax, resin, sealing wax. Very few of the seals have survived. Also, scholars refer to the 63 numbered clauses for Magna Carta. This is a modern system of numbering introduced by Sir William Blackstone in 1759. The original charter formed the single long unbroken text. The four original of 1215 charters were displayed together at the British Library for one day. The 3rd February 2015 to mark the 800th anniversary of Magna Carta. History, 13th century. Background. Magna Carta originated as an unsuccessful attempt to achieve peace between royalist and rebel factions in 1215 and part of the events leading to the outbreak of the First Barons' War. England was ruled by King John III of the given kings. Also, the kingdom had a robust administrative system. The nature of government on the given monarchs was ill-defined and uncertain. John and his predecessors had ruled using the principle of vis est voluntas, or forced will, taking executive and sometimes arbitrary decisions, often justified on the basis that a king was above the law. Many contemporary writers believe that a monarch should rule in accordance with the custom and the law, with the counsel of the leading members of the realm. But there was no model for what should happen if a king refused to do so. He lost most of his ancestral land in France to King Philip II in 1204, and struggled to regain them for many years, raising extensive taxes on the barons to accumulate money to fight a war which ended in expensive failure in 1214, following the defeat of the Allies and the Battle for Bouvines. John had to sue for peace and pay compensation. John was already personally unpopular with many of the barons, many of whom owed money to the crown, and little trust existed between the two sides. The triumph would have strengthened his position, but in the face of a defeat, within a few months after he returned from France, John found that rebel barons in the north and east England were organizing resistance to his rule. The rebels took oath that they would stand fast for the liberties of the church and the realm, and demanded that the king confirm the Charter of Liberties that had been declared by King Henry I in the previous century, and which was preceded by the barons to protect their rights. The rebel leadership was unimpressed by the standards of the time, even disputable, but were united by their hatred of John. Robert Fitzwater, later elected leader of the rebel barons, claimed publicly that John had attempted to rape his daughter and was implicated in a plot to assassinate John in 1212. John had a council in London in January 1215 to discuss potential reforms, and sponsored discussion in Oxford between the agents and the rebels during the spring. Both sides appealed to Pope Innocent III for assistance in the dispute. During the negotiations, the rebellious barons produced An initial document, which historians have termed the Unknown Charter for Liberties, which drew on Henry I's Charter for Liberties for much of its language. 7 articles from that document later appeared in the Articles of Barons as a subsequent charter. It was John's hope that the Pope would give him valuable legal and moral support, and accordingly, John played for time. The king declared himself to be a papal vassal in 1213 and correctly believed that he could count on the Pope for help. John also began recruiting mercenary forces from France, although some were later sent back to war, giving the impression that the king was escalating the conflict. In the first move to shore up his support, John took an oath to become a crusader, a move which gave him additional political protection under the church law, even though many felt the promise was insincere. Letters backing John arrived from the Pope in April, but by then the rebel barons had organized into a military faction. They congregated at Northampton in May and renounced their feudal tie to John, marching on London, Lincoln, and Exeter. John's effort to appear moderate and conciliatory had been largely successful, but once the rebel held London, they attracted a fresh wave of defectors from the royalists. The king offered to submit the problem to a committee for arbitration with the Pope as the supreme arbiter, but this would not attract the rebels. Stephen London, the Archbishop of Canterbury, had been working with the rebel barons on their demands. After the successful papal arbitration failed, John instructed London to organize peace talks. Great Charter for 1215. John met the rebel leaders and Runnymede, a water meadow on the south bank of the River Thames on the 10th June 1215. Runnymede was a traditional place for assemblies, but it was also located on neutral ground between the royal fortress of Windsor Castle and the rebel base at Stennis, and offered both sides the security of rendezvous where they were unlikely to find themselves at a military disadvantage. Here the rebels present John with their draft demands for reform. The Articles of Barons, Stephen London's pragmatic efforts and mediation over the next 10 days turned those incomplete demands into a charter capturing the proposed peace agreement. A few years later, this agreement was renamed Magna Carta, meaning Great Charter. By the 15th June, general agreement has been made on the text, and on 19th June, the rebels renewed the oaths of loyalty to John, and copies of the charter were formally issued. Also, as a historian David Carpenter noted, the charter wasted no time on political theory. It went beyond simply addressing individual baronial complaints and formed a wider proposal for political reform. It promised protection for church rights, protection from illegal imprisonment, access to swift justice, and most importantly, limitation on taxation and other feudal payments to the crown, with certain forms of feudal taxation requiring baronial consent. It focused on the rights of freemen, in particular the barons. However, the rights serfs were included in Article 16, 20, and 28. Its style and content reflect Henry I's charter's liberties, as well as a wider body of legal traditions, including the royal charter issued to towns, the operation of the church and the baronial courts, and the European charters, such as the Statute of Premiers, and what the historians later labeled Clause 61, or the Security Clause. A council of 25 barons would be created to monitor and ensure John's future adherence to the charter. If John did not conform to the charter within 40 days of being notified for a transgression by the council, the 25 barons were empowered by Clause 61 to seize John's castles and lands until, in their judgment, amend has been made. Men were to be compelled to swear oaths to assist the council in controlling the king, but once redress had been made for any breaches, the king would continue to rule as before. In one sense, was not unprecedented, as the king had previously conceded the rights of individual resistance to the subs if the king did not uphold his obligations. Magna Carta was, however, novel in that it set up a formal recognized means of collective coercing the king. The historian Wilfred Warren argued that it was almost inevitable that the clause would result in civil war. It was crude in its method and disturbing in its implications. The barons were trying to force John to keep to the charter. But Clause 61 also was so heavily weighed against the king that this version of the charter could not survive. John the rebel barons did not trust each other, and neither side seriously attempted to implement the peace accord. The 25 barons selected for the new council were all rebels, chosen by the more extremist barons, and some among the rebels found excuses to keep their forces mobilized. Dispute began to emerge between the royalist factions and those rebels who had expected the charter to return lands that had been confiscated. Clause 61 of Magna Carta contained a commitment from John. They would seek to obtain nothing from anyone in our own person or through someone else, whereby any of those grants or liberties may be revoked or diminished. Despite this, the king appealed to Pope Innocent for help in July, arguing that the charter compromised the Pope's rights and John's feudal lord. As part of the June peace deal, the barons were supposed to surrender London by the 15th August, but this they refused to do. Meanwhile, instructions from the Pope right in August, written before the peace accord, with the route that the papal commissioners excommunicated the rebel barons and suspended London from office in early September. Once read the charter, the Pope responded in detail in the letter dated 24th August and arriving in late September. He declared the charter to be not only shameful and demeaning, but also illegal and unjust, and John had been forced to accept it. Accordingly, the charter was annulled, awarded for all validity forever. Under threat of excommunication, the king was not to observe the charter, nor the barons tried to enforce it. By then, violence broke out between the two sides. Less than 3 months after it had been agreed, John and the loyalist barons firmly repudiated the feudal charter. The First Barons' War erupted. Rebel barons concluded that peace with John was impossible, and turned to Philip II's son, the future Louis VIII, for help, offering him the English crown. The war soon settled into a stalemate. The king became ill and died on the night of the 18th October 1216, leaving the 9-year-old Henry III as his heir. There are basically then a list of the participants in the 1215 consular names in Magna Carta. We'll bypass that. And the council of 25 barons will bypass that as well. Then the excommunicated barons, bypass that. Now let's see Greek charter for 1216. All of the charter for 1215 was a filler, and the peace treaty was rejected under the new government of the young Henry III, as well as drawing support away from the rebel faction. On his deathbed, King John appointed a council of 13 executioners to help Henry reclaim the kingdom. He requested his son to be placed into the guardianship of William Marshal, one of the most famous knights in England. William knighted the boy, and Cardinal Gula Biccheri, the papal legate to England, then oversaw his coronation and Gloucester Cathedral on the 28th October. The young king inherited a difficult situation with over half England occupied by the rebels. And the substantial support, though, from Guiala, who intended to win the civil war from Henry and punish the rebels. Guiala set about to strengthen the tie between England and the papacy, starting with coronation itself, during which Henry gave homage to the papacy, recognizing the pope and his feudal lord. Horologius III declares Henry was the pope's vassal and ward, and that the legate had complete authority to protect Henry and his kingdom. As additional measure, Henry took the cross, declared himself a crusader, and thereby entitled special protection from Rome. It was not going well for the loyalists, but Prince Louis and the rebel barons were also finding it difficult to make further progress. John's death had diffused some of the rebel concerns, and the royal castles were still holding out in the occupied parts of the country. Henry's government encouraged the rebel barons to come back to his cause in exchange for the return of their lands, and reinstated a version of the 1215 chapter, albeit having first removed some of the clauses, including those unfavorable to the papacy, and the clause 61, which had set up the Council of Barons. The move was not successful, and opposition to Henry's new government hardened. Great Charter for 1217. In February 1217, Louis set sail for France to gather enforcement. In his absence, argument broke out between Louis's French and English followers, and Cardinal Gola declared that Henry's war against the rebels was equivalent of a religious crusade. This declaration resulted in a series of defections from the rebel movement, and the tide of the conflict swung in Henry's favor. Louis returned at the end of April, but his northern forces were defeated by William Marshall at the Battle of Lincoln in May. Meanwhile, support for Louis' campaign was diminishing in France, and he concluded that the war in England was lost. The next term was Cardinal Gola, under which Louis would renounce his claim to the English throne. In return, his followers would be given back their lands, any sentences for excommunication would be lifted, and Henry's government would promise to enforce the charter for the previous year. The proposed agreement soon began to unravel amid claims from some lawyers that it was too generous toward the rebels, particularly the clergy, when they joined the rebellion. In the absence of settlement, Louis stayed in London with the remaining forces, hoping for the arrival of reinforcement from France. When the expected fleet did arrive in August, it was intercepted and defeated by Louis and the Battle of Sandwich. Louis entered into fresh peace negotiations, and the factions came to agreement on the final Treaty of Lambeth, also known as the Treaty of Kingstown, on 12 and 13 of September 1217. The treaty was similar to the first peace offer, but excluded the rebel clergy whose land and appointments remained forfeit. It included a promise, however, that Louis' followers would be allowed to enjoy their traditional liberties and customs, referring back to the Charter of 1216. Louis left England as agreed and joined the Albigensian crusade in the south of France, bringing the war to the end. The Great Council was called in October and November to take stock of the post-war situation. This council is thought to have formulated and instituted the Charter for 1217. The charter resembled that of 1216, although some additional clauses were added to protect the rights of the barons over their feudal subjects, and the restrictions on the crown's ability to levy taxation were watered down. There remained the range of disagreement about the management of the royal forests, which involved a special legal system that had resulted in the source of a considerable royal revenue. Complaints existed over both in implementation, those cores, and the geographical boundaries of the royal forests. On contemporary charter, the Charter of the Forest was created pardoning existing forest offenses, imposing new controls over the forest cores, and establishing a review of the forest boundaries. To distinguish the two charters, the term Magna Carta Libertatum, the Great Charter for Liberties, was used by the scribe to refer to the large document which in time became known simply as Magna Carta, the Greek Charter of 1225. Magna Carta became increasingly embedded into English political life during Henry VIII's minority. As the king grew older, his government slowly began to recover from the Civil War, regaining control of the counties and beginning to raise revenue once again. Taking care not to overstep the terms of the charters, Henry remained minor, and his government's legal ability to make permanently binding decisions on his behalf was limited. In 1223, the tensions over the standards of the charters became clear in the royal court when Henry's government attempted to reassert its rights over its properties and revenues in the counties. Facing resistance from many communities, and argued, if sometimes incorrectly, that the charters protect the new arrangements. This resistance resulted in an argument between Archbishop London and William Brewer over whether the king had any duty to fulfill the terms of the charters, given that he had been forced to agree to them. On this occasion, Henry gave oral reassurance that he considered himself bound by the charters, enabling a royal inquiry into the situation in the counties to progress. 2 years later, the question Henry's commitment to the charters re-emerged when Louis VIII of France invaded Henry's remaining provinces in France. Poitou and Gascony, Henry's army in Poitou was under-resourced, and the province quickly fell. It became clear that Gascony would also fail unless reinforcements were sent from England. In early 1225, a great council approved a tax of £40,000 to dispatch an army which quickly retook Gascony. In exchange for agreeing to support Henry, the barons demanded that the king reinstate Magna Carta and the Charter of the Forest. The content was almost identical to the 1217 versions, but in the new version, the king declared that the charters were issued of his own spontaneous free will, and confirmed them with the royal seal, giving the new Great Charter, the Charter of the Forest of 1225, much more authority than the previous versions. The barons anticipated that the king would act in accordance with these charters, subject to the law, and moderated by the advice of the nobility. Uncertainty continued in 1227, when he was declared of age and able to rule independently. Henry announced that future charters had to be issued under his own seal. This brought into question the validity of the previous charters issued during his minority, and Henry actually threatened to overturn the Charter of the Forest unless the taxes promised in return for it were actually paid. In 1253, Henry confirmed the charter once again in exchange for taxation. Henry placed a symbolic emphasis on rebuilding royal authority, but his role was relatively subscribed by Magna Carta. He generally acted within the terms of the charters, which prevented the crown from taking extrajudicial actions against the barons, including the fines and the expropriations that has been common under his father John. The charter did not address the sensitive issue of the appointment of royal advisors and the distribution of patronage and their lack of any means of enforcement if the king chose to ignore them. The inconsistency with which he applied the charter over the course of the rule alienated many barons, even those within his own factions. Despite the various charters, the provision of royal justice was inconsistent and driven by the needs of immediate politics. Sometimes action would be taken to address a legitimate baronial complaint while on other occasions the problem would simply be ignored. The royal courts which toured the country to provide justice at the local level, typically for lesser barons and the gentry claiming grievances against major lords, had little power, allowing the major barons to dominate the local justice system. Henry's rule became lax and careless, resulting in a reduction in royal authority in the province and ultimately the collapse of his authority at the court. In 1258, a group of barons seized power from Henry in a dictate, citing the need to strictly enforce Magna Carta and the Charter of the Forest, creating a new Brownell-led government to advance reform through the provisions of Oxford. The barons were not militarily powerful enough to win a decisive victory and instead appealed to Louis IX of France in 1263 to 1264 to arbitrate on their proposed reforms. Reformist barons argued their case based on Magna Carta, suggesting that it was inviolable under English law and that the king had broken its terms. Louis came down firmly in favor of Henry, but the French arbitration failed to achieve peace as well as the barons refused to accept the verdict. England slipped back into the Second Barons' War, which was won by Henry's son, the Lord Edward. Edward also invoked Magna Carta in advancing his cause, arguing that the reformers had taken matters too far and were themselves acting against Magna Carta. In a considerate gesture after the barons had been defeated, in 1267, Henry instituted a statute of Marlborough, which included a fresh commitment to observe the terms of Magna Carta. Then lists names as witness to the Charter or the Declaration. Now let's see the next section, Great Charter for 1293 Statute. King Edward I reinstituted the Charter for 1225 in 1297 in return for the new text. It is this version which remains the statute today, although with most articles now repealed. The Confirmatio Cartarum, confirmation of charters, was instituted in Norman French by Edward I in 1297. Edward, needing money, had taxed the nobility, and they hand arms themselves against him, forcing Edward to institute a confirmation of Magna Carta, the Forest Charter, to avoid a civil war. The nobles had sought to add another document, the Dentalegio, to Magna Carta. Edward's government was not prepared to concede this. They agreed to the institute of the Confirmatio, confirming the previous charters and confirming the principle that taxation should be by consent, although the precise matter of that consent was not laid down. The passage mandates that a copy should be distributed in cathedral churches throughout our realm, there to remain, and shall be read before the people 2 times by the year. Hence, the permanent installation of a copy in Salisbury Cathedral in the confirmation second article, it confirms that if any judgment be given from henceforth contrary to the points of the charters aforesaid by the justices, or by any other ministers that held a plea before them against the points of the charters, it shall be undone and holden for naught. With the confirmation of the charters in 1300, additional documents were granted as the article Super Cartus. The article upon the charters was composed of 17 articles and sought in part to deal with the problem for enforcing the charters. Magna Carta as a forest charter was to be issued to the sheriff of his county and should be read 4 times a year at the meetings of the county courts. Each county should have a committee for 3 men who would hear complaints about the violation of the charters. Pope Clement V continued the papal policy for supporting monarchs who ruled by divine grace against any claims in Magna Carta which challenged the king's rights and annulled the Confirmatio Cartarum in 1305. Edward I interpreted Clement V's papal bull announcing the Confirmatio Cartarum as effectively applying to the Antisulis press cards, although the latter was not specially mentioned. In 1306, Edward I took the opportunity given by the Pope's banking to reassert forest law over large areas which has been disforested. Both Edward and the Pope were accused by some contemporary chroniclers of perjury. It was said by Robert Necker Scott that Robert Bruce refused to make peace with Edward's first son, Edward II, in 1312 with the justification, "How shall the king in land keep faith with me, since he does not observe the sworn promises made to his liege man?" Magna Carta's influence on English medieval law. The Great Charter was referred to in legal cases throughout the medieval period. For example, in 1226, the Knights of Lincolnshire argued that the local sheriff was charging customary practice regarding the local courts, contrary to the liberty which they ought to have by the charter of the Lord King. In practice, cases were not brought against the king for breach of Magna Carta and the Forest Charter, but it was possible to bring a case against the king's officers, such as his sheriffs, using the argument that the king's officers were acting contrary to liberties granted by the king in the charters. In addition, medieval cases refer to the clauses in Magna Carta which dealt with specific issues such as worship and dower, debt collection, and keeping rivers free for navigation. Even in the 13th century, some clauses of Magna Carta rarely appeared in legal cases, either because the issues concerned were no longer relevant or because Magna Carta has been superseded by more relevant legislation. By 1315, half the clauses of Magna Carta were no longer actively used. 14th and 15th centuries. During the reign of King Edward III, 16 measures, later known as the Six Statutes, were passed between 1331 and 1369. They sought to clarify certain parts of charters. In particular, the Third Statute in 1354 redefined Clause 25 with free man becoming nobleman of whatever estate or condition he may be. It uses the phrase due process law for legal judgment, it appears, or the law of the land. Between the 13th and 15th century, Magna Carta was reconfirmed 32 times, according to Sir Edward Coke, and possibly as many as 45 times. Often the first item of the parliamentary business was a public reading and reaffirmation of the charter, and as in the previous century, parliaments often exacted confirmation of it from the monarch. The charter was confirmed in 1423 by King Henry VI. By the mid-15th century, Magna Carta ceased to occupy a central role in English political life as monarchs reasserted authority powers which had been challenged in the 100 years after Edward I's reign. The Charter remained a text for lawyers, particularly as a protector of property rights, and became more widely read than ever as printed versions circulated. Levels of literacy increased. 16th century. During the 16th century interpretation of Magna Carta, the First Barons' War shifted. Henry VII took power at the end of the turbulent Wars of the Roses, followed by Henry VIII, and extensive propaganda under both rulers promoted the legitimacy of the regime, the illegitimacy of any sort of rebellion against royal power, and the priorities of supporting the crown in its argument with the papacy. Taylor historians rediscovered the Barnwell Chronicler was more favorable to King John than other 13th century texts, and as a historian Ralph Turner described the view King Zhang in a positive light as a hero struggling against the papacy, showing little sympathy for the Great Charter or the rebel barons. Pro-Catholic demonstration during the 1536 uprising cited Magna Carta, accusing the king of not giving it sufficient respect. The first mechanically printed rendition of Magna Carta was probably the Magna Carta Convalias Antiquias Statutes of 1508 by Richard Punson. Also, the early printed versions of the 16th century incorrectly attributed the origins of Magna Carta to Henry III and 1225 rather than to Zhang and 1215, and accordingly worked from the later text. An abridged English language edition was published by John Russell in 1527. Thomas Bartlett, Punson's successor and the royal printer during 1530 to 47, printed an edition of the text along with other Asian statutes in 1531 and 1540. In 1534, George Fourier published the first unabridged English language edition of Magna Carta, dividing the charter into 37 numbered clauses. At the end of the 16th century, there was an upsurge in antiquarian interest in England. This work concluded that there was a set of Asian English custom and laws temporarily overthrown by the Norman invasion of 1066, which had then been recovered in 1215 and recorded Magna Carta, which in turn gave authority to important 16th century legal principles. Modern history knows that although this narrative was fundamentally incorrect, many refer to it as a myth, it took on great importance among the legal historians of the time. Antiquarian William Lambert, for example, published what he believed was the Anglo-Saxon Norman law codes, tracing the origins of the 16th century English Parliament back to this period, misinterpreting the dates of many documents concerned. Francis Bacon argued that Clause 39 of Magna Carta was the basis of the 16th century jury system and judicial processes. Antiquarians Robert Bill, James Morris, and Richard Coulson argued that Magna Carta was a statement of liberty and a fundamental supreme law empowering English government. Those who question these conclusions include the Member of Parliament Arthur Hall faced sanctions. 17th and 18th centuries. Political tensions. In the early 17th century, Magna Carta became increasingly important as a political document in arguments over the authority of the English monarchy. James I and Charles I both propounded great authority for the crown, justified by the doctrine of the divine right of kings, and Magna Carta was cited extensively by the opponents to challenge the monarchy. Magna Carta, it was argued, recognized and protected the liberty of individual Englishmen, made the king subject to the common law of the land, formed the original or the tribe by jury system, acknowledged the Asian origins of Parliament because of Magna Carta and this Asian constitution. English monarch was unable to alter these long-standing English customs. Although the argument based on Magna Carta were historically inaccurate, they nonetheless carried symbolic power, and the Charter has an immense significance during that period. Antiquarians such as Sir Henry Spelman describe it as a most majestic and sacrosanct anchor to English liberties. Sir Edward Coke was the leader in using Magna Carta as a political tool during this period, so working from 1225 1805 version of the text, the first printed copy of the 1215 Charter, only emerged in 1610. Coke spoke and wrote about Magna Carta repeatedly. His work was challenged at the time by Lord Ellesmere, and modern historians such as Ralph Turner and Claire Bray have critiqued Coke as misconstruing the original charter anachronistically and uncritically, and taking a word selective approach to his analysis. More sympathetically, G.C. Holt noted that the history of the charters had already become distorted by the time Coke was carrying out his work. In 1621, a bill was presented to Parliament to renew Magna Carta. Although this bill failed, lawyer John Sheldon argued during Daniel's case in 1627 that the rights habeas corpus was backed by Magna Carta, who supported the petition rights in 1628. We cited Magna Carta in its preamble, attempting to extend the provisions and to make them binding on the judiciary. The monarchy responded by arguing that the historical legal situation was much less clear-cut than was being claimed, retreated the activity for antiquarians, arrested Coke for treason, and suppressed his proposed book on Magna Carta. Charles initially did not agree to the petition rights and refused to confirm Magna Carta in any way that would reduce his independence as a king. England descended into civil war in the 1640s, resulting in Charles' execution in 1649. Under the Republic that followed, some question whether Magna Carta agreement with the monarch was still relevant. Anti-Cromwellian pamphlet published in 1660. The English Devil said that the nation had been compelled to submit to this tyrant law or to be cut off by him, nothing but a word, and the blow his will was his law. Tell him of Magna Carta, he would lay his head on his sword and cry Magna Fata. In the 2005 speech, the Lord Chief Justice for England and Wales, Lord Wolfe, repeated the claim that Cromwell had referred to Magna Carta as Magna Fata. The radical groups that flourished during this period held differing opinions of Magna Carta. The Levelers rejected history and the law as presented by their contemporaries, holding instead to an anti-Normanism viewpoint. John Lilburn, for example, argued that Magna Carta contained only some of the freedom that had been supposedly existing under the Anglo-Saxon before being crushed by the Norman York. The leveler Richard Overton described the charter as a beggarly thing containing many marks of intolerable bondage. Both saw Magna Carta as a useful declaration of liberties that could be used against governments they disagreed with. Geraint Winstanley, the leader of the more extreme diggers, stated that the best laws that England has, that is, Magna Carta, were gotten by our forefathers in potestate petitioning unto the kings that still were their taskmasters. Yet these best laws are yokes and manacles, tying one sort of people to be slave to another. Clergy, gentry, had gotten freedom, but the common people still are, and are being left to certain to work for them. Glorious Revolution. The first attempt and the proper historiography was undertaken by Robert Brandy, who refuted the supposed antiquity of a parliament and belief in the immutable continuity of the law. Brandy realized that the liberties of the Charter were limited and argued that the liberties were the grant of the king. But putting Magna Carta in historical context, it cast doubt on its contemporary political relevance. Historical understanding did not survive the Glorious Revolution, which, according to the historian G.J.A. Pocock, marked a setback for the course English historiography. For the Whig interpretation of history, the Glorious Revolution was an example of reclaimed Asian liberties. Enforced with Lockean concepts, the Whigs believed the England Constitution to be a social contract based on documents such as Magna Carta, the Petition Rights, the Bill of Rights, the English Liberties, 1680, in later versions often British Liberties by the Whig propagandist Henry Kerr, 1688, was the chief polemical book that was influential and much reprinted in the American colonies as well as Britain, and made Magna Carta central to the history and the contemporary legitimacy of the subject. Ideas of the nature of the law in general were beginning to change. In 1716, the Septennial Act was passed, which had a number of consequences. First, it showed that the Parliament no longer considered previous statutes unassailable. It provided for a maximum parliamentary terms of 7 years, whereas the Triennial Act 1694, enacted less than a quarter of a century previously, had provided for a maximum term of 3 years. Also greatly extended the powers of Parliament. Under this new constitution, monarchical absolutism was replaced by parliamentary supremacy. It was quickly realized that Magna Carta stood in the same relation to the king in Parliament as it had to the king without the Parliament. This supremacy would be challenged by the likes of Granville Sharp. Sharp regarded Magna Carta as a fundamental part of the Constitution and maintained that it would be treason to repeal any part of it. Also held that the Charter prohibited slavery. Sir William Blackstone published a critical edition of the 1215 Charter in 1759 and gave it its numbering system still used today. In 1763, members of Parliament John Wilkes was arrested for writing a inflammatory pamphlet number 45, the 23rd April 1763. He cited Magna Carta continually. Lord Camden denounced the treatment of Wilkes as a contravention of Magna Carta. Thomas Penn, in his Rights Men, would disregard Magna Carta as a Bill of Rights on the ground that they were not a written constitution devised by elected representatives. Used in the 13 colonies and the United States. When English colonists left for the New World, they brought royal charters that established the colonies. The Massachusetts Bay Company Charter, for example, stated that the colonists would have and enjoy all liberties and immunities of free and natural subjects. The Virginia Charter for 1606, which was largely drafted by Sir Edward Coke, stated that the colonists would have the same liberties, franchises, and immunities as people born in England. The Massachusetts Body for Liberties contains similarity to Clause 29 of Magna Carta. When drafted as a Massachusetts General Court with Magna Carta and the chief embodiment of English common law, the other colonies would follow their example. In 1638, Maryland sought to recognize Magna Carta as a part of the law of the province, but the requests were denied by Charles I. In 1687, William Penn published the excellent privilege of liberty and property being the birthright of the free-born subject of England, which contained the first copy of Magna Carta printed on American soil. Penn's comments reflect Coke's, indicating a belief Magna Carta was a fundamental law. The colonists draw on English law books, leading them to anachronistic interpretation of Magna Carta, believing that it guaranteed trial by jury and habeas corpus. Development of parliamentary supremacy in the British Isles did not constitutionally affect the 13 colonies, which retained adherence to English common law, but it directly affected the relations between British and the colonies. When American colonists fought against Britain, they were fighting not so much for new freedom, but to preserve liberties rights that they believed to be enshrined in Magna Carta. In the late 18th century, the United States Constitution became the supreme law of the land, recalling the manner in which Magna Carta has come to be regarded as a fundamental law. The Constitution's Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property without the due process of law, a phrase that was derived from Magna Carta. In addition, the Constitution included a similar right in the Suspension Clause and Article 1, Section 9. The privilege of the right of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. If this preclaim, each of these preclaims, no person may be imprisoned or detained without evidence that he or she committed a crime. The 19th Amendment states that enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The writers of the United States Constitution wish to ensure that the rights they already held, such as those that they believed were provided by the Carta, would be preserved unless explicitly curtailed. The U.S. Supreme Court has explicitly referenced Edward Cook's analysis of Magna Carta as an antecedent of the Sixth Amendment's right to a speedy trial. 19th to 21st centuries interpretation. In the so weak interpretation of Magna Carta and its role in constitutional history remained dominant during the 19th century. The historian William Stubbs' Constitutional History of England, published in the 1870s, forms a high watermark of this view. Stubbs argued that Magna Carta has been a major step in the shaping of the English nation, and he believed that the barons and Runnymede in 1215 were not just representing the nobility, but the people of England as a whole, standing up to a tyrannical ruler in the form of a King John. This view of Magna Carta began to recede. The late Victorian jurist and historian Frederick William Maitland provided an alternative academic history of 1899, which began to return Magna Carta to its historical roots. In 1904, Edward Jinks published an article entitled The Myth of Magna Carta, which undermines a previously accepted view of Magna Carta. Historians such as Albert Pollard agreed with Jinks in concluding that Edward Cook had largely invented the myth of Magna Carta in the 17th century. These historians argued that the 1215 Charter had not been referred to liberty for the people at large, but rather to the protection for brownie rights. This view also became popular in wider circles. And in 1930, Seller and Eatman published their parody in English history, 1066 and all that, in which they mocked the supposed important Magna Carta and the promises of universal liberty. Magna Carta was therefore the chief cause for democracy in England, as is a good thing for everyone, except the common people. In many literary representations of medieval past, however, Magna Carta remained a foundation of English national identity. Some authors use the medieval roots of the document as an argument to preserve the social status quo, while others point to Magna Carta to challenge perceived economic injustices. The brand new order for Magna Carta was formed in 1898 to promote the Asian principles and values felt to be displayed in Magna Carta. The legal profession in England and the United States continued to hold Magna Carta in high esteem. They were instrumental in forming the Magna Carta Society in 1922 to protect the meadows of Runnymede from development in the 1920s, and in 1957 the American Bar Association erected the Magna Carta Memorial and Runnymede. The prominent lawyer Lord Denning described Magna Carta in 1956 as the greatest constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot, repeal of articles, and constitutional influence. Radicals such as Sir Francis Burdett believed that Magna Carta could not be repealed. But in the 19th century, clauses which were obsolete or had been suspended began to be repealed. Repeal of Clause 26 in 1829 by the Offences Against the Person Acts 1828, was the first time clause of Magna Carta was repealed. For the next 140 years, nearly the whole Magna Carta, 1297, as a statute, was repealed, leaving just Clause 1, 9, and 28 still in force in England and Wales. After 1969, most of the clauses were repealed in England and Wales by the Statute Law Revision Acts 1863, and in modern Northern Ireland and also in the modern Republic of Ireland by the Statute Law Ireland Revision Acts 1872. Many later attempts to draft the constitutional forms of government trace their lineage back to Magna Carta. The British dominions, Australia and New Zealand, Canada, except Quebec, and formed the Union of South Africa and Southern Rhodesia, reflected the influence of Magna Carta in the laws, and the Charter's effect can be seen in the laws for other states that evolved from the British Empire. Modern legacy. Magna Carta continued to have powerful, iconic standards in British society, being cited by politicians and lawyers in support of constitutional positions. Its perceived guarantee for trial by jury and other civil liberties, for example, led to Tony Benn's reference to the debate in 2008 over whether to increase the maximum time terrorism suspect could be held without charge from 28 to 42 days, the day Magna Carta was repealed. Also rarely evoked in court in the modern era, in 2012, the Occupy London protesters attempted to use Magna Carta in resistance to their eviction from St. Paul's churchyard by the City of London. In the judgment, the master of the rolls gave the short shrift, noting somewhat dryly that also Clause 29 was considered by many the foundation of the rule of law in England. He did not consider it directly relevant to the case, and that the two other surviving clauses ironically concerned the rights of the church of the City of London and could not help the defendants. Magna Carta carried little legal weight in modern Britain, as most of the clauses have been repealed and relevant rights ensured by other statutes. But the historian James Holt remarked that the swallow of the 1215 Charter in national life is reflection of the continued development of English law and administration, and symbolic of the many struggle between authority and the law over the centuries. The historian W.L. Warren had observed that many who knew little and cared less about the content of the Charter have, in nearly all ages, evoked its name with good cause, for it meant more than it said. Also remains a topic of great interest to historians. Natalia Fried characterized the Charter as one of the holiest of of cows in English medieval history, with debate over its interpretation and meaning unlikely to end. In many ways, still a secret text, Magna Carta is generally considered part of the uncodified constitution of the United Kingdom. In the 2005 speech, the Lord Chief Justice of England and Wales, Lord Wolfe, described it as the first of a series of instruments and now are recognized as having a special constitutional standards. Magna Carta was reprinted in New Zealand in 1981 as one of the imperial acts in force there. Clause 29 of the document remained in force as a part of New Zealand law. The document also continued to be honored in the United States as an antecedent of the United States Constitution and the Bill of Rights. In 1976, the UK lent one of 4 surviving originals of the 1215 Magna Carta to the United States for their bicentennial celebrations, also donated an ornate display case for it. The original was returned after 1 year, but a replica and the case are still on display in the United States Capitol crypt in Washington, D.C. Celebration of the 800th anniversary. The 800th anniversary of the original charter occurred on the 15th June 2015, and organizations and institutions planned celebratory events. The British Library brought together 4 existing copies of the 1215 manuscript in February 2015 for a special exhibition. British artist Cornelia Parker was commissioned to create a new artwork, Magna Carta, an embroidery, which was shown at the British Library between May and July 2015. The artwork is a copy of the Wikipedia article about Magna Carta as appeared on the document of 799th anniversary, the 15th June 2014, and hand embroidered by over 200 people. On 15 June 2015, a commemoration ceremony was conducted in Runnymede at the National Trust Park, attended by British and American dignitaries. On the same day, Google celebrated the anniversary with a Google Doodle. The copy held by Lincoln Cathedral was exhibited at the Library of Congress in Washington, D.C. from November 2014 until January 2015. A new visitor center at Lincoln Castle was opened. For the anniversary, the Royal Mint released 2 commemorative 2-pound coins. In 2014, Bury St. Amos in Suffolk celebrates the 800th anniversary of the Barons' Charter of Liberties, said to have been secretly agreed there in November 1214. Content. Physical copy. I'm not going to read this. Okay, so that's that. Later exemplifications. We don't need to go to all the technical clauses. That might be useful later day for better start later another time. And key clause in detail. Well, that's good to read. Let's read. First, we have granted to God, and by this our present charter, have confirmed for us our heirs forever, and the Church in England shall be free, and shall have all her whole rights and liberties inviolable. We have granted also and given to all the freemen of our realm, for us our heirs forever, this liberty is underwritten to have and to hold to them, and the heirs of us and our heirs forever. So that is the first one. Now this is the 9th one. The city of London shall have all the old liberties and customs which it has been used to have. Moreover, we will and grant that all other cities, boroughs, towns, and the barons of the 5 ports, as with all other ports, shall have Other ports shall have all the liberties and free customs. That's going to be 29th. No freeman shall be taken or imprisoned or be disseized of his freehold or liberties or free customs, or to be outlawed or exiled or any otherwise destroyed. No will pass upon him, nor condemn him, but by lawful judgment of his peers, or by the law of the land. We shall sell to no man, will not deny or defer to any man, either justice or right. Let's conclude this reading.